Hello, my name's Kate Redshaw and I'm a senior lawyer in the employment team at Burgess Salmon. And today I'm delighted to be joined by one of our directors, James Green. And James, we're not here today for once to be talking about COVID. Actually, we're going to be talking about your specialist subject, which is the senior managers and certification regime. And in particular, the topic of fitness and propriety in the financial services sector. So if you're in HR, compliance or in-house legal at solo regulated FCA firms, you're in the right place. As you'll be aware, the senior managers and certification regime came into force for solo regulated FCA firms in December 2019. And firms are going to have to complete their implementation projects by March next year. Now, one of the key requirements of this regime is for firms to make assessments about the fitness and propriety for their senior managers and certification staff. So, James, I'm looking forward in this conversation to be discussing how firms should make these assessments and some of the issues that will arise in the course of making these assessments. So perhaps we can begin, James, just by, explaining a little bit more about why this is important.
Yes, absolutely. Thanks, Kate. I mean, certainly the concept of fitness and propriety in the financial services sector isn't new. It's been around for a while. But I think it's recently become more important for firms for a couple of reasons. Firstly, as you mentioned, the introduction of the senior managers and certification regime has seen a much bigger emphasis from the regulator on the importance of developing good culture, good conduct throughout the financial services sector. So fitness and propriety is very much on the regulator's radar, and therefore I think very high up the corporate agenda as well. And then the second reason this is particularly important is because SMCR places a much heavier burden on firms themselves to make these assessments, whereas previously it might have been the regulator that had that responsibility. So firms are going to have to grapple with some difficult issues around fitness and propriety. And as you mentioned, this is very much on their to-do list at the moment because implementation has got to be completed by March 2021. So the clock is very much ticking on the need to make these assessments.
Okay, so should we start, James, at the very, very beginning, which we all know is, as Julie Andrews would say, it's a very good place to start. So which employees need to be assessed as fit and proper?
That's an important question. So, as I mentioned, the regulator's talking about the importance of good culture throughout the firm, and you can see that in things like the conduct rules, which apply to almost all employees in financial services firms, apart from some ancillary functions. But when we're talking about fitness and propriety assessments, what we're really talking about is three distinct groups of people. So there's a need to carry these out for senior managers, for certification staff, and for non-executive directors in solo regulated firms. So senior managers, that's for core firms, that's chief executive, other executive directors, the employee with responsibility for compliance oversight, so that's head of compliance typically, and the money laundering reporting officer. Certification staff, that's heads of business units, the client dealing function, material risk takers, and then finally we've got non-executive directors as well.
Okay, so we've dealt with the who's. Perhaps we could move on next then to the when's. When do these assessments need to be carried out?
Yeah, so they need to be carried out on a number of occasions during the employment life cycle. I think we've got a need to make them when a firm's proposing to put forward a senior manager for approval by the regulator, because the firm's going to want to carry out its own due diligence before doing that. There's also a need for a firm to carry out those tests when it's carrying out its own fit and proper assessments on its certification staff. So when it's proposing to appoint someone to a certification function, there'll be need to carry out that assessment. And there's also an ongoing requirement. So for senior managers and for certification staff, the firm's going to have to assess them as fit and proper on an ongoing basis, at least annually. So this is sort of idea that this is an ongoing requirement, not just an implementation point. And then finally, there's a need to carry out the assessment when a firm is proposing to appoint a non-executive director as well.
Okay. I suppose this sounds like it might be a bit of an obvious question, but I guess it's a really important one. What do we mean by fitness and propriety? What criteria should firms be using to make those assessments?
Yeah, well, there's a fit and proper test for employees in the FCA handbook, which is commonly referred to as FIT, and that sets the criteria which firms need to think about. And the FCA set out what it, in its view, are the most important considerations, and that's really three things. That's a person's honesty, integrity, and reputation. Secondly, it's their competence and capability. And then finally, and also importantly, it's their financial soundness. And all those three elements are going to go towards a fit and proper assessment for any individual.
Okay, and am I right in thinking, James, that the FCA does give some additional guidance on those considerations? And assuming I am right, are you able to expand on those?
Yes, absolutely. So when we're looking at honesty, integrity and reputation, there's some guidance in the handbook from the regulator which talks about the sorts of things that will be relevant to that assessment. So here we're thinking about whether someone's been convicted perhaps of a criminal offence, whether they've got judgments made against them in civil proceedings, particularly if that's something relating to financial services matters or indeed to any element of dishonesty. They'd also want to know whether the person's been subject to any disciplinary proceedings or disciplinary investigation, whether that's by the SCA or other regulators. And there's a number of other factors as well which are set out in the handbook. If we look at competence and capability, and that's all about the person's ability to carry out their role, here the guidance requires us to look at the FCA training and competence requirements, of course, but also just the individual's general experience in the role, as well as their attendance at training, particularly mandatory training sessions. What sometimes is missed out, I think, here is the need to consider that person's performance of the role in the round. So is there enough operational resource for that person to be able to actually carry out their role effectively? Do they have enough time to carry out their role effectively? That's all part of an assessment of whether they're capable of carrying out that function. And then finally, we've got financial soundness. Well, that's a matter of whether the individual has ever been declared bankrupt, whether they're subject to any judgment debt, or whether they've made any arrangement with their creditors.
Okay, so when we're looking at these different factors, James, are we just concentrating on them in relation to financial services activities, or does it go wider than that?
No, you're absolutely right. These have wide application. The regulator's been very clear that they can apply to both financial misconduct, but also non-financial matters as well. And you can see that, of course, if you question an individual's honesty and integrity, if they've been involved in dishonesty or fraud, if that's not related to financial services matters, it's not going to matter to your assessment of whether they're fit and proper to do their role. I think you'd still want to take that into account. And in fact, the regulator's been clear that this sort of conduct can encompass matters such as sanctions for discrimination or indeed sexual misconduct during the course of employment. And those sorts of matters, it thinks, are an indicator of poor culture. So they're really directly relevant to whether people are fit and proper to perform these sorts of functions and whether they're going to help drive that improved culture and good conduct across the sector that the regulator wants to see.
Okay, I see. So it goes beyond financial services activities at work. That's clear and that's helpful. What about into non-work life? Does non-work life come into it?
Absolutely, it can. I think there can be some difficult questions here for firms if they're having to determine whether matters outside the workplace are or are not relevant to fitness and propriety. So we can see, for example, that a minor driving offence, well, that probably isn't relevant to overall fitness and propriety, or may not be. But if the matter was relating to a different sort of poor behaviour, so something involving dishonesty, then that could well be relevant to fitness and propriety in the workplace, even if that dishonesty was not actually directly connected with work. We can all remember the case of the managing director at an asset manager who was found guilty of fare dodging over a number of years by exploiting that loophole in the ticket barriers, the regulator was very clear that although that conduct wasn't directly related to work, it was outside the workplace, it was absolutely relevant to that individual's honesty and integrity. That's a pretty clear-cut case, I think, and there have been many other examples like that. But I think there's going to be other cases where conduct outside the workplace arises and firms have to make an assessment where the boundaries might be more blurred, or whether the firm perhaps has got limited information about actually the precise circumstances of what's occurred. And I think those are going to be much the harder cases to deal with.
Yeah, no, I think you're absolutely right there. As you say, the example you gave is a clear-cut one, but you can think of many examples where it will be much more difficult. I'd like to move on now, James, to the actual process of making the assessments. Is there a process that's set out somewhere, or is it up to firms to put together their own assessment process?
No, well, thankfully the regulator's not been prescriptive in terms of the process that has to be followed. There's a huge range of firms within the solar regulated sector, so a whole range of different sizes and complexities, and so there isn't a one-size-fits-all approach here. But I think there are some aspects which are going to be consistent across many firms. So if we take, for example, a firm that's proposing to carry out an annual assessment of an employee for a certification role, there's going to be a number of sources of information that the firm will need to take into account when it's making that fitness and propriety assessment. And I think our experience here is generally this works best if it's integrated into a firm's existing HR process, their existing procedures, so things like appraisals or performance reviews can be woven in alongside these things. But the sorts of things a firm will need to think about are firstly, well, career history. So what's the past disciplinary record? What's the past conduct record? Firms here are likely to ask for self-declarations, which individuals are going to have to complete in order to cover these sorts of matters. We'd look at training records, I think, particularly mandatory training, as I mentioned. A reference, or indeed a regulated reference, might also be relevant. So in the case of a regulated reference, that's going to actually have express details about fitness and propriety issues, which might well be relevant. And then for senior managers, there's going to be a need to undertake a criminal records check as well. And then finally, we'll have the usual sorts of things, usual sorts of background screening checks to assess things like credit worthiness. And I think what's important here for HR and compliance professionals when they're undertaking these checks is that there's going to be some really important procedural and record keeping requirements. Much of this information is going to be highly confidential. Criminal record checks, for example, it needs to be securely stored and accessed on a need-to-know basis only.
Yes, no, absolutely, good point. And presumably, James, although it doesn't set down a prescribed procedure, I'm assuming the FCA has got some sort of best practice guidance on this.
Yeah, absolutely. There's some guidance on the website, as you might expect, in terms of the sorts of characteristics of a good assessment process. The regulator said that it shouldn't simply be a rubber stamping exercise, so there needs to be any sort of active investigation. Firms actually need to identify issues that need addressing, and in some cases that might result in some staff failing these checks and not being passed as fit and proper. Similarly, when a firm's assessing staff competence, that needs to be done by reference to the specific role, so not just a sort of tick box exercise. And the regulator might expect firms to be identifying, as a matter of course, some development needs for some of its employees as part of these assessments. So a clean bill of health in every case might raise some eyebrows. Surely you'd expect this sort of assessment to throw up some points for development from time to time.
Yeah, interesting point, that, isn't it? Now, I suppose the crunch question, really, James, now for you is, what do you do if your assessment shows somebody is not fit and proper?
Yeah, you're quite right. It's absolutely fundamental, I think, to the whole regime here. So there's going to be immediate consequence because the individual cannot perform the role for which they've been approved. So they must cease acting as a senior manager or as a certified person. And it's also going to be relevant for their ongoing employment, of course, because if you've got an issue which is relevant to fitness and propriety, then that issue is also going to be highly relevant to ongoing employment. So we might be in a situation where we're thinking about termination of employment in those circumstances. it's going to be much neater to do that if a firm's had the chance to amend employment contracts so that these are said to be, so in ongoing employment is conditional upon these assessments being made, and then a failure to pass those assessments could well lead to dismissal.
And I'm assuming there's also requirements in certain circumstances to report this to the regulator.
Absolutely right. There's good old Principle 11 in the handbook, the obligation to tell the regulator about anything about which it might reasonably expect to have notice. So there may well be a need to make a report under that principle if it's something particularly serious. For a senior manager, there'll be an immediate need to report to the regulator if an individual is no longer fit and proper. And there's also an ongoing annual requirement to report when a firm's taking disciplinary action against an individual for conduct breaches. And finally, I think the other relevant factor is going to be a regulatory reference. So fitness and propriety is one of the issues that must be reported in that reference. It's part of the mandatory form of reference. So if an issue has arisen in relation to fitness and propriety, there'll be a need to make future employers aware of that issue.
Okay, so I mean, it's really clear, isn't it, that you're going to have to take a great deal of care with making these assessments, because, you know, it's potentially career ending for somebody if you find that they're not fit and proper.
Absolutely correct. Yeah, I think that really reinforces the need to pay very close attention to these sorts of issues. But at the same time, the regulators made it clear that they would expect these assessments to be robust, and therefore firms can't shy away from investigating issues that do arise. Clearly, if a firm does decide that someone's not fit and proper, there could be a challenge to that decision from the employee because, as you said, the serious consequences for that employee as a result of that finding. So an employee might try and argue that the employer's breached their obligations of trust and confidence in the way that it's conducted that fit and proper assessment if it was done in an unreasonable way. I think that's really uncharted territory at the moment, but you can see certainly that in some cases litigation might ensue because the employer is going to really fight hard to preserve their reputation and to preserve their career. And I think the financial stakes could be quite high here because you have an employee who potentially is facing, as you said, the end of their career in financial services, and therefore a claim could be brought for very substantial damages if we're talking about career long losses where a person couldn't work in the sector again. So I think, I emphasise again, it's really important that firms take great care when carrying out these assessments, and in fact it may well be best to get some legal advice on difficult issues when they arise so that those can be identified early and managed carefully in the right way.
Well, thank you, James. That brings us, I think, to the end of what we wanted to cover today. And there's plenty for people to grapple with before implementation at the end of March next year. I know, James, that you're very happy to field questions. So if you want to get in touch with James to ask anything about what your assessment process might look like, or indeed some of those difficult issues that James raised, and he'd be happy to advise on those as well. So do feel free to get in touch. Thank you very much for watching.